propriedade intelectual é responsável hoje por até 80% do valor das empresas. Mas isso não acontece apenas porque as empresas dão valor à sua propriedade intelectual. A propriedade intelectual vale muito porque a sociedade dá valor ao esforço de solucionar seus problemas e de lhe criar oportunidades. Nosso congresso desse ano vai reunir especialistas em propriedade intelectual, juristas, economistas do desenvolvimento e da inovação para nos guiarem nessa importante discussão. O pano de fundo escolhido não poderia ser melhor: as maravilhas da cidade do Rio de Janeiro. Para comemorar seus 60 anos de existência, a ABPI reunirá os participantes nos mirantes deslumbrantes do Pão de Açúcar, ícone turístico do Rio de Janeiro, aclamado por visitantes do mundo inteiro. Durante 3 dias, teremos a oportunidade de nos encontrarmos, fazer negócios e, sobretudo, de discutir e aprofundar nosso entendimento do papel da propriedade intelectual frente aos desafios brasileiros. Da consolidação do agronegócio ao desenvolvimento do turismo e de indústrias avançadas, da transformação digital e da transição energética ao estímulo ao empreendedorismo e à inclusão social. Participe e se engaje com o compromisso social do Congresso da ABPI de 2023. Esperamos vocês de 20 a 22 de agosto na cidade maravilhosa do Rio de Janeiro.
Bom dia a todos. Good morning. It's a pleasure to host the second event of our committee, e-games and video games sport committee. Today we have the pleasure of hosting this event and bringing you the discussion around the IP considerations for esports through the lenses and the optics of the International Olympic Committee. It's my pleasure to share this event today with my co-chair, Andrea Lerner, who's going to introduce our guests today. Andrea, do you want to take on from here? And just as a reminder, I'm sure everybody is aware, but at the end, we'll open for questions at the end of our panel. So please submit your questions at the end or throughout the presentation in the chat, and we'll submit to our guests at the right time. Andrea is with you.
Thank you, Fernanda. Good morning. I am going to introduce our panelists. Maxime Vuille is a legal counsel specialized in IP contracts and content at the International Olympic Committee, IOC. In 2021, he has been involved in the Olympic Virtual Series, the first ever Olympic event for virtual sports. Before joining the IOC, Maxime worked in the fields of trademark prosecution and biotechnology. He's a Swiss qualified lawyer and holds an LLM in international and European IP law from Trinity College in Dublin. Marco Yago is an IP legal counsel at the IOC and member of the Madrid Bar Association. Before joining the IOC, he has worked during more than 8 years in Spanish law firms specializing in intellectual property. His expertise mainly covers IP strategy and management, including trademark prosecution before the Spanish Patent and Trademark Office and EUIPO, litigation involving all kinds of IP rights, as well as unfair competition and advertising consumers law. He holds a double degree in business management and law by the Universidad Autónoma de Madrid. Thank you again for joining us this morning. You may begin your presentation. Thank you.
Thank you, Andrea. Thank you very much. Well, first of all, thank you for giving us the opportunity to participate in this great event. I mean, it's a pity not being there physically, but we are very glad to participate with you all, and thank you for the presentation. Maybe I can share my screen and we can start the presentation.
Yes, please.
Okay. Okay, let me see. No. Sorry, I'm having some troubles.
Okay.
Because I have many screens open. Sorry.
That's all right. The day of computer bugs.
Yeah, today they don't want that.
Perfect. Now it's on full screen.
Okay, so can you see my screen with the presentation?
Yes, and yes, full screen. Yes.
Okay, great. So thank you again. Max, if you want to introduce a little bit of yourself.
Yeah, perfect. Thank you very much, Fernanda and Andrea, for the very kind presentation. Good morning, everyone. It's, as Marco said, a pleasure and an honor to be with you this morning, this afternoon for us. As Andrea said, we are both IP lawyers with Marco, but we will start with, let's say, a small disclaimer. We are not esports specialists. So the idea today is really, not trying to give you an academic lecture about esports, but rather to share with you what the IOC is doing in this very particular field, and to talk about the challenges that we have faced so far. Marco, if you can go to the next slide. That's the plan of this morning's presentation. So we will start by quickly mentioning what are the elements of the Olympic Games which are protected by intellectual property rights. Also trying to highlight the importance of IP, the key role that it plays in the funding model of the Olympic movement. We will then explain what is the IOC's position with regard to video games, and also take a few minutes to talk about how esports is currently, let's say, fitting within the Olympic ecosystem. And afterward, we will cover the core topic of the presentation, which is IP aspects in esports. And then we'll try to broaden a bit the debate by making parallels with other areas of the new virtual world that we have now all entered into. And we will obviously finish by answering, or at the very least trying to answer any question you may have. So Marco, yeah, thanks. Thank you. So let's start with intellectual property in the Olympic Games. So there are plenty of aspects or elements of the game which are protected by IP rights. And the most important for us are trademarks, because they protect the Olympic rings, the World Olympic itself, the logo of the different edition of the Olympic Games, or even certain mascots. And beside trademarks, we have copyright, which is protecting all the main assets, such as the one that you can see on the screen. So the medals, the torches, the official film, etc. And as you also probably know, copyright would also provide protection when it comes to broadcast. Apart from trademark and copyright, we also sometimes register some assets as design to get, let's say, an extra protection. But it is something that in full transparency is quite rare. We also sometimes rely on what we call the sui generis rights. This is something that is known in the European Union, and which is protecting or granting an extra protection to a database owner. And finally, patents. Obviously, technology is a very important aspect of the Olympic Games, not only for the performance. We all remember like the swimsuits that were used 10 years ago, where all the records were being broken, but also in terms of the coverage of the game, the broadcasting, because you can see now new technology. For example, I guess that as Brazilian people, you are not the biggest ski fans, but still now, if you ever happen to watch a race, you'll see that there's a drone following the skiers down the slope, and it is a very impressive technology. So all this to say that there is a lot of technology, and there is a lot of patented technology used at the Olympic Games. But let's say that the IOC is not using it itself, but it's rather the athletes, the broadcasters, or the other stakeholders. So the IOC is not filling patent application itself, basically. So that was it in a nutshell for the elements of the Olympic Games, which are protected by IP rights. And yeah, thank you, Marco. As you can see on the screen, the two main sources of revenue from the money that is generated by the IOC, they come from the broadcasters. You can see what is 61% here, and the sponsor 30%. And this money, as you can see, well, it is generated by the IOC, but then it's redistributed to other members of the Olympic movement, so NOCs, athletes, International Sports Federation, Organizing Committee, etc. Can go to the next slide.
So basically, as Max is saying, we are an entity based on intellectual property. This is our core business. I mean, we are not selling goods, we are not selling services. Our main core is intellectual property right. That's why it's very important for us to have a good strategy and also to foresee new challenges in the esports organization.
Yeah, exactly. IP it's our product. It's what we sell basically. So just here this slide to highlight the importance, the key role played by IP, because the funding model we have is based on exclusivity. So you have the broadcasters, they pay to be the only one allowed to broadcast the games in a specific territory. And you have the sponsors who pay to be the only one to use the Olympic rings, or more generally to associate with the Olympic Games for certain categories of product and services. So in order to protect this exclusivity, you need to have strong IP rights, in particular to fight against ambush marketing and piracy that we're going to discuss a bit later. Because obviously, if you let third parties, let's say, illegally stream the games live, or if you let a competitor of your sponsor use the Olympic rings, the value of what we sell of this IP is going to decrease considerably. Can move to the next slide. So that was the first part, which was meant to set the stage. And well, Marco went to the next slide, but we wanted now to take about the IOC and the video games, and we thought that it was fitting to have a picture of Japan's former Prime Minister Shinzo Abe dressed up as Mario Bros. And maybe you remember this image because that was during one of the ceremony of the Rio Games that took place in 2017. You can go to the next slide, thanks. So at the IOC, we have a document which is called Olympic Agenda 2020+5. And this basically is our roadmap. You know, it's setting the objective that we want to achieve in the coming years. And there are 15 recommendations, but basically they're objectives. And as you can see on the screen, one of them is to encourage development of virtual sports and further engage with video gaming communities. So you see, it is something which is very high on the IOC's agenda, and which is considered as a key area on our side to develop. And I would say that there are two main reasons for that. The first is that we want to lead people who are playing video games to more and more like gradually practice physical activity. That's for one. And the second reason is that we are trying to connect with this new generation, which is called Gen Z. And that's something, to be fully honest with you, that we have kind of struggled to do so far, because young people, the way they watch content is very different now. You know, they want something which is short, which is entertaining. So you cannot ask them to sit on their couch and watch a full 10,000-meter race anymore. So it's not working. So engaging with video game community is the way that we have found to talk to this new audience, to interact and to connect with them. And if you go back one slide, you can see on the right that we had already in the past, you know, deals with Sega. It was licensing deals for a video game which was called Mario and Sonic at the Olympic Games. So we've been active in this field for a while, but if you go to the next slide now, thank you. In 2021, we really decided to step up, and we organized the first ever Olympic virtual competition. The name was Olympic Virtual Series. It was composed of 5 different sports, and these were, let's say, very much our first steps. We were kind of exploring what we could do, what we couldn't do, what works, what doesn't work. And we decided to include a bit of everything. So we have, for example, virtual regatta, which is you can see here on the bottom left of the screen. And it's a mobile sailing games without any physical activity. Then the image on top is Zwift. You know, this is a mix between physical activity on a bike and seeing the result on the screen. And apart from that, we had like rowing, and this was basically not even virtual because it was just people on their rowers in a gym and then entering the data into a digital environment. So that was in 2021. And if you go to the next slide. Thank you. In 2022 and 2023, we are organizing the second edition, and there is a new name now. It's called Olympic Esports Series. We had qualifiers until now that took place entirely online. And in 2 weeks' time, we will have the finals that will be on site in Singapore. So later on, we're gonna talk a bit about the IP aspects which are involved in these games. But at this stage, it's probably already relevant to point out that for sport shooting, which is one of the 10 sports which will feature during this year's competition, the video game which was selected is Fortnite. And you've probably all already heard about Fortnite. It's a metaverse kind of video game. And as we will see, it adds an extra layer of complexity when it comes to protecting your intellectual property. If you go to the next slide. Thank you. So now let's move to esports within the Olympic ecosystem. And you can directly go to the next slide. Thank you. So the first question is probably, what is esport? So it has been created based on 2 words, electronic and sports. So it gives you already kind of an idea of what it is, what it includes. But obviously there are different levels. So you can simply have people controlling player with a control, and that would typically be your FIFA game. And that's traditionally what we would refer to as esport per se. Then you can have, as I mentioned before, a Swift type of game where you have both a physical activity and a result on screen. And that would probably what we usually refer to as more virtual sport. And finally, you can have, let's say, a totally immersive experience with sensors and VR glasses, but we are not there yet. And one of the hot topic which has been like debated over the past year is whether esports is a sport. And here on the screen, we have selected a couple of decisions that we think are relevant. The first one is from 2017. It was in the context of a tax case, so nothing to do with sports law. And the Court of Justice reached the conclusion that Bridge, which I don't know if you know what it is, it's a card game, it was not a sport because it did not have a sufficient level of physical activity, basically. So this decision was not on esport, but as you can probably imagine, this argument was used very often afterwards by people who consider that esport is not a sport, to say that considering there is not enough physical activity, it cannot be considered as a sport. There was also a report from the Swiss Federal Office for Sport. They basically reached the same conclusion that the Court of Justice of the EU. There was different reasons for that, but among them, lack of physical activity, ethics issues, risk of competition manipulation, etc. And well, it was maybe not relevant for the whole world, but for us it was, because as you might know, the IOC is based in Switzerland. And yeah, like I said, it's a tricky debate with people having a different opinion. Each and every one of us has her or own his or her own view on the matter. And 2 weeks ago, for example, the Swedish Sport Federation took a totally different approach, and they decided to officially recognize esport as a sport. And the question is, what about the IOC? This is something that we are very often asked about. Can esports become an Olympic sport? Can move to the next slide. Thank you. And we received this question plenty of time, and this is obviously something that we have thoroughly assessed, and the answer for the moment is not yet. Just to explain, so in short, in order to be considered as an Olympic sport, you need to follow certain specific processes, and you need to meet certain requirements. And among these requirements, you need to be organized under the responsibility of one single international federation, which will be at the top and which will regulate the sport, basically. So that's the model that you can see on the left of the screen. And at the moment in esport, it is not the case at all, because you have plenty of different games, which means that you have plenty of different publishers, and they are the ones setting the rules. So there is no uniformity whatsoever, and there is not what we call a commonly recognized, let's say, regulatory entity or regulating body. And now, since we are here to talk about IP, it is interesting to see already the difference between what we call traditional sport and esports. So if you take a football game, for example, it is not protected by intellectual property rights. Of course, if you take other examples such as figure skating, you might have elements that are protected by IP rights. For example, performance protected by neighboring rights. You have, the costume or the music protected by copyright, etc. But still, the competition, the sport itself, is not protected by IP right, and that is the big difference with esports, where there is underlying IP, like IP in the video game itself, and the rights holder on this IP are the publisher. So we have this traditional model, which is a pyramid shaped, and then comes these totally new actors, the publishers, and it's at the moment very, very difficult to see where they would fit in. So all this to say that there is still some way to go, probably, before esport can become an Olympic sport. And on this note, I will give the floor to Marco.
Okay, thank you, Max. So now we are going to focus on the intellectual property aspects of esports. So first of all, we are going to do a quick recap on the intellectual property rights that the video games and the esports competitions involve, and then we are going to jump to the IOC challenges, or the challenges we are having for protecting our intellectual property rights and on the upcoming esports competition. Bear in mind that the competition hasn't taken place yet, so some of these challenges are more future risk than actual past menaces. So let's start to the IP aspects. First of all, we have a video game, and the first question that we should ask is, what is from an intellectual property point of view a video game? Of course, this will also depend on the specific legal framework that we are talking about. We have legal frameworks that consider video games more like a computer program. Others, the minority ones, consider video games more as a audiovisual work. others try to consider this as an addition of different copyright elements. And in Europe, we have a specific European Union Court of Justice judgment of 23 January 2014 in the case between PC Box and Nintendo, where it was analyzed exactly what kind of protection we should seek for video games from an IP perspective. And the conclusion was that video games are complex matter, are complex works. So they are not just a computer program, but also they have other elements like graphic, like sound elements that can be protected by other IP rights and that are not encrypted in computer language. So basically, we have an addition, a group of IP rights composing this big work, which is the video game. Here we can see the categories of intellectual property rights involved, also with some examples as in relation to video games. So we have copyright protection, mostly, of course, for the characters. For here we have our loved Mario Bros, and well, we have also copyright for the code, for the software code in most of the countries. The art of the design, the interface, the music of the video game, but also we have trademarks. As Max said, trademarks are very important for the IOC, and here we can see that we have protected as trademarks the publisher brand, the video game logo, the tagline, but also other elements of the video game, which sometimes it's a little bit challenging to protect as trademark. Here we have some examples. We have the trademark, the European trademark for Fortnite, but also we have the European trademark for one of the main characters of the super known video game now is called Among Us. And maybe you don't know that, but I know this video game for my little brother. And then also we have other elements protected as trademark. For example, hardware elements, like here we see a trademark protecting the Nintendo Switch console. Then we have patents. Here the discussion is a little bit more complex because it depends on where you are to see how much you can protect with patents. In the European countries, normally you can limit the protection of patents to hardware elements more than software, but you know that in the US they have a more flexible approach with software, and they can protect the technical innovation of the software. And here in the screen you can see an actual example of an US patent granted. You see that it's B2, so it's granted for systems and methods for automated image processing for images with similar luminosities. And then we have other rights, trade secrets, of course. These are not exclusive rights, but these are also important in the video game industry for cost and pricing information, also for algorithm and things not protected specifically by the copyright code. Then we have also designs. This is not that important. Because their protection is rather limited, and normally it's just for the visual of the design. But there are some registered designs, for example, for the Pokeball in Pokemon and at the European IP office. Then we have the IP aspects of the competition. Max, if you want the floor.
Yeah, thank you, Marco. So yeah, here the idea is basically to take a few minutes to show you how what Marco just said concretely translates into the context of what we are doing at the IOC, so the Olympic series, and in particular the Olympic Esporte Week that will take place in 2 weeks in Singapore. To illustrate this, we decided to use this image, which is from the 2021 edition, because obviously this year's edition did not happen yet. And just by having a look at it, you can see directly that there are several IP aspects to be taken into account. The first one probably is the name of the competition. So we had lots of talk because obviously, you know, words such as esports and series, they are generic, so they cannot be registered as trademark. Everybody can use them. And we didn't want to have a name of a competition that people can use freely, because obviously it would increase the risk of ambush marketing activity. So at the end, we eventually decided to add the word Olympic to the competition name, and also to create a logo which can be registered as a trademark. Then you can also see that there are plenty of Olympic branded assets within the video game. For example, the Olympic rings, but you can also see the look and feel a bit everywhere on this image. So that meant that we had to enter into licensing agreement with the publisher so that they can include this Olympic branded element into the video games. And this was quite of a lengthy and at times painful process, because obviously, like, you need to be very careful and very clear when you define the scope of the license that you grant. The next point is we needed to make sure that we had control over the, let's say, audiovisual content which was resulting from the competition. So that implied, as I said before, getting a license from the publishers on the pre-existing and underlying IP in the video game. That also meant that we needed to get the consent from all the participants regarding the use of their image, because I don't know if you've already watched an esport competition, but you can very often see the participant on the screen, or you can also hear them. And finally, there were like some third-party content and music included in the feed, and we needed to make sure that we had secured all the necessary rights appropriately. One other aspect which has proved extremely tricky was how to protect the exclusivity granted to our sponsors. Because as you can imagine, the publisher, they already have some deals in place. Sometimes they already have their own sponsors. And apart from that, there were like some, let's say, technical constraints that were making things a bit more difficult. So our approach is quite simple. What we request from the publisher is a so-called clean venue video game, which means that no third-party brand can appear in the video game, with the only exception of the IOC sponsor. So you can probably not see on the screen because it's quite small, but if you look carefully, you see that these cars are Toyota cars and that the tires are from Bridgestone. So both are Olympic sponsors. And these are actually the only brands from third party that you will see while playing the video game. So, well, actually, what I'm saying is not entirely true, because if you look at the bottom left of the image, you will see that there is a small reference to Gran Turismo. And here, what they told us is that they could not remove it due to technical reasons. I don't know whether it was the truth or it was just a smart way to keep their name in there, but in any case, we had to agree on that. So that's why that's also Gran Turismo brand appearing.
Max, can I interrupt you just to make sure I understood? So even the publisher cannot have their name attached to the content on screen of the content? Is that what it is?
Yeah, exactly. So, I mean,
wow.
We had different deals with the publishers, but basically we have full control over the images. So nobody can use the images without our prior consent. And we've been very strict and clear on this. That's the basis of the deal. Is it clear or?
I see. Great. Yeah, no, it's totally clear. Yes, absolutely. Now I understand.
Okay, thank you. No, please don't hesitate. If there is something which needs clarification,
I will.
Thank you.
No, great so far.
Okay, cool. The last element I wanted to mention with regard to this virtual competition we are organizing is regarding broadcasters. And in this case, such competition, they fall outside the scope of the exclusive rights that we grant to them. So we did not have specific obligation vis-a-vis them. That made our life much easier for sure. And what we did is that we decided to work on a non-exclusive model. and the competition will even be streamed for free on our website. So at this stage of the process, we are really targeting mass audience and not trying to sell exclusive right to make money. Marco, you can go to the next slide. So IP challenges in the new virtual world. We will start by giving you some example of challenges that we face in the real world, and then Marco will explain you a bit later how this applies to the virtual world. You can go to the next slide. One of the challenges that we face at the IOC is called ambush marketing. And as you can see, it's defined on the screen. It is the fact of creating an undue association with the Olympic Games. So basically, it is when a third party tries to benefit from, let's say, the reputation from the Olympic Games without paying a sponsorship right. I assume that since you are all IP lawyers, you are probably familiar with this concept, but sometimes a reminder is useful. If you go to the next slide, Marco. Thank you. We usually distinguish two types of practices. First, we have what we call a flagrant ambush. And it is, when it's kind of obvious, it tends to reproduce the characteristic element of a brand or of an event. And that's typically what you can see here with Tic Tac on the left and Schweppes on the right. And most of the time, it constitutes IP right infringement, and it is generally pretty easy and straightforward to stop the ambushing activity. But then you have more sophisticated approach, which is, let's say, crafted towards exploiting the gaps within the legal protection. And this might prove very much difficult to fight against. And especially now, because big companies, what they do is that they hire expert lawyer to help them to advise on how to associate with a brand or an event while not crossing the line, so staying within the legal boundaries. And now that I'm saying that, I hope that you guys in the audience are not advising on company on how to ambush us, because that we would basically shoot ourselves in the foot by making this presentation. But anyway, on the screen, you have like example of more sophisticated ambush with Red Bull and Monsters, where they're not using really the trademark, but rather only elements that the public associate with them. So you see the mark of the claws of Monster on the left, and you see the font and the color of Red Bull on the helmet on the top right. Next slide. Okay, mindful of the time, maybe I'm going to skip this one. Can go to the next one. Okay, yeah, this one is pretty funny. So in the lead up to the Tokyo 2020 Olympic Games, Nike launched a Japanese-inspired cloth collection. And you know how they decided to call this collection? They called it Ambush. So you see, they're not hiding. They are even like promoting the fact that they are ambushing the games. It has even become almost a marketing tool for them. If you go to the next slide, thanks. Quickly, apart from ambush marketing, so there are other challenges that we are facing. First, piracy with company, for example, offering VPN to watch illegally the games, for example. You have counterfeiting, obviously. You can see here on the right, the very cute panda bear mascot of the 2022 Olympic Games, which is among the most counterfeited Olympic product ever. And finally, you have this M&M's example, which is a trademark infringement, and usually it is also linked with ambush marketing activities. Marco, over to you.
Thank you, Max. So now, why should the IOC, or why we believe that we will face new challenges in this new esports industry? Well, as Max already introduced, this is a new scheme, very much more complex, with more actors we have the publishers, we have the competition organizers, we have the players and teams, but also we have influencers, content creators, and users. It's very important to know that here the users and influencers and content creators may have an impact from an intellectual property perspective, may infringe our IP rights, and the scope of this infringement can be much wider than in traditional sports industry. Also, there are other particularities of the virtual industry. We have, of course, territoriality and definition. It's much more difficult to understand where you have to enforce your IP rights when any infringement takes place in the virtual world. There is an interconnection between the different actors. As I said before, users, influencers, they can have much more impact for publishers, as you will see, for example, in the modification of the games by users. So there is a much more interconnection between the actors, which makes more difficult the enforcement of the IP rights. And of course, the advertising method is a little bit different. We have in-gaming advertising, which has much more possibilities probably than in the physical world. Here we can see an example of MasterCard and League of Legends in a static in-gaming advertising, but also we have dynamic in-gaming advertising when the character of a video game, for example, interacts with some advertising material. For example, there is a T-shirt wore by the character with Nike or other brands. So what are the changes for the ISC? Some of them have been already mentioned by Max. So thank you for that. But we are trying to differentiate between the challenges that we are facing before the competition and during and after the competition. Before the competition, of course, it's a very big challenge. It has been the negotiation with the publisher and all the organization of the competition for the ownership of the IP rights. Of course, we are not interested in owning the amendments that the publisher have made for the specific competition, because it is not exactly the game. They had amended it. They have developed some changes in the software to make this possible. But we are very sensitive to other ownership of IP rights, as Max said, the look and feel, etc. So another big challenge has been to bear in mind the goodwill of the trademark when promoting the competition. We will look at that a little bit later. The trademark protection in these new goods and services, virtual goods and services, and as Max said, the clearance of all the IP rights involved for the publisher, from the teams, the images right, etc. Then we have particularities of ambush marketing during and after the competition. In this section, we will talk about some cases that we have seen in the industry rather than examples of the IOC, because since this is something pretty new for us, and we don't have much examples of this, but there are other examples in the industry that gives us some tips and clues to see what kind of changes we will foresee. Then we have trademark and copyright infringement, unauthorized broadcasting, and then counterfeiting in the venues or in the next to the place where the Olympic Esports Week is going to take place, and of course enforcement issues, as we will see. Then trademark registration. So the trademark registration in the virtual world for the organization of a competition is not something very challenging for us, because our core trademarks normally are registered in class 41. We are talking about entertainment, about sporting and cultural activities. So this will be just an expression of this kind of services. So this is not that challenging, but we are facing some challenges for the protection of our trademarks in relation to NFTs. Why is that? Because NFTs, there is some some discussion about what kind of classes should be categorized as NFTs. And meanwhile, the European Union IP Office on its guidelines says that the NFTs can be classified as non-fungible tokens in class 9. The services related to NFTs can be classified in services, but taking into account the impact in the real world. So, for example, if we are talking about virtual transport services in gaming in the virtual world, we will have to protect this trademark in class 41 as part of the entertainment services, rather than in class 39, which is the physical transport of the goods. We have similar examples in class 35, for example, for the retail of virtual clothing or NFTs, for example. But this is in contradiction, or at least partially in contradiction with what other offices are arguing. For example, we have a recent decision from the Swiss Intellectual Property Office, which says basically that NFTs cannot be classified as products, that you have to classify or register the trademarks relating to NFTs in services classes. So there is some uncertainty yet, but we hope that with the practice and with the years, this will be solved. Then we have another challenges before the competition. This is the first time that the advertising of the sports, of the esports, is closely linked with third parties' IP. So this is one challenge for the goodwill, as I was saying before. This is, as you can see in the screen, you can see the pictogram of the handball in Tokyo 2020. This is the traditional sport. You just promote the discipline, you just promote the Olympic Games and the discipline as a generic denomination within the Olympic Games. But then we are now talking about Taekwondo, masters of the foot and fist in virtual Taekwondo. So there is another party trademark when promoting the competition. And virtual Taekwondo maybe is not as well known as other of our publishers collaborators, because as Max said before, we are having a Fortnite with us in the shooting e-sport competition, and having Fortnite, it's a very good partnership, because one of our main goals is to engage and to raise to have a great impact with this event. So it's easier to do that when you engage when you partner with a well-known trademark as Fortnite. But at the same time, it is a risk, because when the Olympic Esports series was released, we were seeing news like this: Olympics, Fortnite becomes an official esports discipline. This is not what we want, because Fortnite is not an official esport discipline. We are not talking about that. But of course, sometimes it's very difficult to control the impact of your advertising, or mostly when you are in partnership with these big brands. Of course, we have another challenge related to the control of our trademarks, of the trademark relationship with the video game after the competition. But this can be mitigated with the careful choice of the partners, of course, and trying to foresee some contractual remedies in case of misuse of the IOC trademarks after the competition. So let's jump to ambush marketing, which is it's a headache for us, but it's very interesting from an IP perspective. There have been some ambush marketing cases in the industry. For example, we have this one of the most popular ones that I recall is Fallout and Nuka-Cola. This is a video game ambient in the post-apocalypse world, and there is this drink all around the video game, whose trade dress is super similar to Coca-Cola. In this case, you can see the images, like the stripe in the middle, the typography, the colors, etc. In this particular case, Coca-Cola did not, to our knowledge or to the public knowledge, took any actions against Bethesda Studios, probably because it was more advertising for them in a way. But we have another recent case of unauthorized ambush marketing. Fortnite and Wendy's. Fortnite basically released this update on the video game where the fight was between one team defending pizza and one team defending burgers. So this was the perfect opportunity for Wendy's to host or to promote a Twitch live stream event where the core goal was destroying all freezers of at burger restaurant in Fortnite. You can see the picture on the right. You can see it's very similar to Wendy's girl brand image. And yeah, basically this is the goal of this was based on when this tagline, which says that they don't use frozen meat for their burgers. So what Fortnite did, basically they removed burger freezers from the game in the following update, because in these cases, from legal aspect that should be considered is that the use of IP rights in games in many cases can be considered just a parody, just can be considered as part of freedom of speech or the artistic freedom, or even a fair use in some countries, especially in the US. There are other cases of trademark infringement. For example, Call of Duty and Humvees in the Call of Duty video game. I'm sure that you know about this video game. They use the original trademark rights and copyright design of the vehicle. And they so for that reason, AEM General, who own trademark rights and copyrights over the vehicle, sued Activision, saying that basing the action on unfair competition, on trademark infringement, and misleading advertising, basically saying that there was it was creating an undue association between both companies, but the action was dismissed by New York court. Why? Again, it was based on the artistic freedom, and there was no likelihood for confusion. In these cases, the use of trademarks in video games is not easy to challenge from a trademark perspective, because normally these trademarks used in video games are not used as a trademark. They are not used to distinguish a business origin of goods and services, but rather to just to give more added value to the video game or to the atmosphere. So, or more reality to the video game. So it's very difficult from a trademark perspective. Then another big challenges we have in the virtual world is the content created by users and by influencers and gamers. And we have seen some cases, for example, of unauthorized broadcasting by influencers. In Pokimane, she's a Twitch gamer who basically broadcasted herself watching Avatar, the TV show. And her reactions. So Twitch banned Pokimane temporarily, at least. So probably we will see some kind of unauthorized broadcastings by influencers of our content in the future. It's not something very unlikely. But again, we have other contents. I was mentioned before, mods and official servers for massive video games. This is the video games have a huge community. And they normally encourage to make modifications to the video games. For example, Counter-Strike was a modification of Half-Life, and there are so many modifications to the GTA that using other parties' IP. So this is also a source of conflict. And of course, the metaverse and other video games can also be a source of IP infringement. For example, here we see a McDonald's advertising in Minecraft. Here, the problem is that we have some complex schemes to enforce the IP rights. And of course, we have also reputational damages to take into account when going after users and content generators, because at the end of the day, they are the final customer of these video games. And normally publishers are reluctant to go after these kind of mispractices. So let's see a little bit about enforcement anteriority. We have here several kind of models. This is the traditional model for physical infringements on the IOC. You normally have a counterfeiting store or whatever in the real world, so you can initiate legal proceedings, try to request a preliminary injunction, or maybe you can file a seizure of goods request before the customs authority, and then you summon the infringer to national proceedings. And maybe if the infringer is acting in many jurisdictions, you initiate multi-jurisdictional proceedings, so you just go to the national forum where this infringer is based. So normally the pros of this traditional model is that you normally have legal certainty, you have a judgment reliable that you can enforce against this infringer in the future, and also you can be awarded with damages. The problem normally is that these are very long and costly proceedings, and normally you cannot chase everything because it's too costly and it's not worth it sometimes. Now, some years ago, we jumped to many to see many e-commerce infringements, so where you have the traditional approach with legal proceedings, as I mentioned before, with the same elements, and then the platforms initiated or offered some proceedings with takedown request. This takedown request, normally you could file with each of the offers infringing your IP rights. You could file takedown request, and normally the platform, if the infringement is clear cut, they could remove the offer, and maybe they could make a warning to the seller, etc. So the pros of these proceedings are, of course, time and cost. The problem normally is that there are no damages. This is not a good approach for complex matters, and of course you cannot enforce this kind of decisions in the future against the infringer. But now we have the esports IP infringement, so things are getting more and more complicated. Here we have the IP infringement from an economic entity, like a business. So again, normally you should have both proceedings at your disposal. You have the legal proceedings and, of course, the platform proceedings in Twitch, in YouTube, in Facebook Gaming, because all of these platforms normally have terms and conditions where you can see the example of Twitch, where basically the user warrants that the content does not infringe, violate, misappropriate any third-party intellectual property rights. So, and normally these kind of platforms have means and proceedings to take down the content. But now we are talking that maybe the infringement can take place not only on platforms for YouTubers or for influencers in Twitch, but also in the video games, like in Minecraft, in Fortnite, in Skyrim, because these are massive games. So here in these examples, in this kind of video games, the platform is not that mature in regard of the protection of IP rights of third parties. So you can see terms and conditions where you can rely on these terms and conditions to remove the content, but normally the form to take down request, to file the takedown request, is not as mature, and it's more slower, and it's not as mature as in platforms or in Amazon or in e-commerce marketplaces. But in the esports, we have users creating content. As you can see, there is a mod here with Skyrim using Goku from Dragon Ball, and also a mod with Pikachu in Minecraft. So what can you do against this kind of use of your intellectual property? Because maybe these users have many followers, so maybe the scope, the scope of the infringement is super wide. It's not some kid playing with his computer at his home in Alabama. It's somebody that maybe is streaming. So what can you do? It's very difficult from a legal perspective. It's very difficult because these are non-commercial use of third parties' IP rights. These are not normally using trademark as a trademark. They are not identifying the business origin of goods and services. And if you want to rely copyright infringement, that normally is the most successful tool for you, normally the greatest chance of success is for the publisher, because these modifications are using the code of the video game. But the publisher, maybe they don't want to go against the user. Other parties, IP, you can face a defense from the fair use defense, for example. So it's very complicated. Again, we see two examples here. We see that one modification from Pokemon, where you could shoot Pokemon, and also to GTA. Here we see two examples because Pokemon, for example, Nintendo is super reactive against this kind of modifications. And maybe if you see some kind of IP rights in relation to their games, they will be very proactive. But other publishers are not that proactive. And for example, Take-Two, normally there are some news that they send some cease and desist letters to mod creators, but in an unofficial way. So they didn't file a suit. They didn't take down the content with judicial action. So it's very sensitive. this is the how in the esports. So this is the scheme that I have just explained. And other problem is where, because if you want to start legal proceedings, you have to sue somebody somewhere, and the scope of the injunction, it will be limited to the scope of your IP rights. If you are relying on European Union trademark, you will try to have a pan-European injunction. But if you are relying on unfair competition, the territorial limitation will be just that national jurisdiction. So it's super complex also in relation to the territoriality. Max, if you want to jump in with the metaverse.
Yeah, thank you very much, Marco. So I see that time is flying, so I'll be very quick. And you already mentioned trademark, but the same issues in terms of territoriality will apply when it comes to copyright infringement. Let's say that you in Brazil are using one of our assets relying on a copyright exception, and we do not have the same copyright exception in Switzerland. We think, okay, you are using our content in an unauthorized way, so we're going to act against you. Then we'll obviously need to determine where we need to act and what is the applicable law. And we might very well end up, having to file a lawsuit in Brazil where the local law, let's say, is actually authorizing what you're doing. So just to say that this is nothing new. These territoriality issues, we know them since the rise of the internet, basically. But we think that with the emergence of this new technology and these new virtual worlds, such as a metaverse and a similar type of video games, such as Fortnite, it will be exacerbated in the future. We can go to the next slide. Yeah, so this, we just wanted to show you a real example that we have faced recently. So we organized a competition where participants from anywhere in the world could submit designs for the medals of the Youth Olympic Games that will take place next year in Gangwon, South Korea. And we received from one of the participants the image that you can see on the right. And the participant told us that he used an AI to create it. I do not remember whether it was Dolly or another one, but in any case, it was one of these tools where you basically enter keywords and the tool creates an image for you. And this image is allegedly new and original. So what we did is that we eventually decided to refuse this application and to prohibit the use of AI by other participants, mainly for two reasons. The first is that, as you know, IP protects creation of the human mind, so not something which is created by a machine. So we did not know exactly the level of input of the participant himself. And maybe it was just entering, typing keywords in the tool. So in such case, the image might not have been protected by IP rights at all, which means that third parties could have used it without our consent. And this is something we want to avoid because we need to have a certain level of control over our assets. And the other reason is that we didn't know technically how the tool was trained. So obviously, if it was only with a few pictures, there is a risk that some element of a pre-existing image are recognizable within the new image. And this, as you know, can be considered as a derivative work, and it can infringe the rights of the author of the pre-existing original image. So that is the reason why we decided to deny this application. And this example is not related to eSport, but we thought that it was interesting to make this parallel here because more and more in video games, you can see that the players have more freedom, more margin of activity, and they can create more and more within the game. So we think that this type of issue, uncertainty surrounding IP protection, IP ownership, and even like terms of use, this is something that we're probably going to see more and more within the video games too. Marco, let's leave you the floor to conclude.
So before the Q&A, let's wrap up a little bit of some of the topics we have talked about today. Basically, the message is that a new industry means new challenges, but these new challenges, we have to face them with the same IP legal framework. This is very important because we don't have many developments from a legal perspective. We know that there are some developments for artificial intelligence legal pieces, but normally the protection is more focused on the consumer more than on intellectual property rights. So what is the IOC doing to mitigate the risk that we have seen? We are trying to protect the IP portfolio, specifically in the virtual world. We are trying to protect our trademarks. We are trying to anticipate the possibilities of protection, even if sometimes the landscape is not super clear, as we saw with the NFTs decisions of the European Union IPO and the Swiss office. We are trying to choose the partners for these video games very carefully to be sure that we are not engaging with some publisher that is not in line with our values. Of course, we are trying to introduce some actions to mitigate risk of misuse of IOC's trademarks contractually with all our partners. We are trying to build relationship with major players in the games industry, with publishers, but also with platforms. It's very important, the relationship with platforms, as it is also in the e-commerce industry. Of course, we are raising awareness of the legal issues as other stakeholders in the industry before the legislators and other relevant entities. And for example, we had a meeting recently with the European Commission. So it's very important for us to raise our concerns from a legal perspective. And we are partnering with entities specialized in the monitoring specifically of IP infringements on the internet and on the virtual world. So we are taking all the steps we believe to anticipate to the new risk of this new industry for us, and hopefully not very, that will not cause many headaches for us. So thank you. That was all. Now we will have the Q&A session, but of course you can see there our email addresses. So if you feel that there are some pending or additional questions not expressly addressed here, you can just send us an email and we will be happy to answer your query.
Marco and Max, what a great presentation. I actually would like to ask you, Marco, to keep the slide, if you don't mind, just so we have that as a reference for the conversation here. But what a great opportunity I think we all have here of reviewing IP from an inside out and not an outside in the sense of, you know, the IOC being one of the most IP heavy business, I guess, in the world, and still having the challenges of passing to the next phase of IP and business in general, from physical to digital, digital to virtual now. So it's quite incredible to see this and to hear your perspective and the challenges. And I think it feels good that we all know, you know, the tools we have, but we don't know yet how this is going to play out. It depends on so many other factors that is beyond our control. But it was really insightful. I really appreciate you sharing the mindset behind all of this and the concerns. But I wanted to ask a few questions. That's why I asked Marco to keep on this screen. And I encourage everybody in the audience to please submit your questions in the chat, so we can submit the questions here to our panelists. But my question was really around when you talked about monitoring and the partnership with the platforms. Do you see, considering the challenges with jurisdiction, the challenges with how this new model of gaming and even interaction in general, where users have more power to build and be more creative, that's really one of the appeals of this new era of games and platforms. Do you see a growth in self-regulation from the platforms versus waiting for the market, the law to really change and dictate how these questions are going to be addressed? do you sense that the platforms are more willing to play hardball and really become, you know, the regulators of their own industry, in the sense of protecting IP owners? I don't know if Max wants to comment,
Max,
or Marco.
if you want, I can try to answer, Max, and please feel free to jump in.
Sure.
So, I mean, it is true that platforms have a more active role on the IP protection. Platforms, meaning marketplaces, all the big players on the internet, but they also are participating more and more in protecting other parties' IP rights, because from the legislators we are putting much more pressure on them from a liability perspective. So it is like a cascade. The legislators can try to increase the liability of IP infringements in all these big players on the internet, and then they cascade the liability with the terms and conditions on the users. And maybe the users complain about the freedom of internet, that we are trying to steal this kind of principle of the internet. But at the end of the day, it's legislators who are, of course, democratically chosen by the people. So there is a democratic also argument behind those kind of pressures. But yeah, but I mean, yes, there is more self-regulation. It's different if you see the takedown request forms and the proceedings that they internally put in place. It depends on the platform to see the complexity and the effectiveness of these proceedings. So there is some kind of self-regulation, but I mean, I think that being optimistic, we will see some standardized. In a few years, always late because legal.
Way too late.
But I mean,
that's true. From an IP owner point of view, a month later is way too late. Yeah,
that's true. And I think what Marco said is, I mean, I fully endorse. And what we have been like seeing with regard to social media and marketplaces so far is exactly what Marco said, is that platform, they tend to be very careful. When there is like a clear-cut case, the takedown is very easy. But when it's more in a gray area, when the user is arguing that there might be a fair use exception or another one, then the process gets much trickier. So that's why building the relationship and trying to convince them that the scope of your IP right is as broad as possible in advance is really key, in order then to act in a timely manner to stop infringements.
Fernanda, we have a question
reacting
here.
Right? Yeah.
If we have time, I think we have.
Yeah, we definitely have time.
It's a question from Andrea Oliveira. Great presentation, congrats. On the AI model, I do agree with the solution, but it may become blurrier if the contestant does not announce that the design is AI-based. Are you able to deploy technology to identify that the design was created by AI?
Yeah, that's a very good question. And at the moment, we do not have like in-house, or we do not even have a partnership, with a technology company which can detect what is created based on existing content, or what is created by AI and what would be created by a human mind. So in this case, what we did is that we had undertakings according to which the participants were, giving us certain warranties in terms of the creative process. And as part of that, they were like warranting that they were not using an AI tool. So that's how we have handled it so far. But obviously, if any of them had lied, I'm not sure we would have been able to detect it. But as Marco said, like, tools are also being developed to monitor this kind of things. So in the future, we might very well have this at our disposal.
That's true. The market is getting ready for it, right? We were all surprised with the AI technology and with the metaverse in the last couple of years. And I think a lot of suppliers, I guess, of services are maturing up to catch up with that. And that was going to be my next question about monitoring. How difficult have you found so far to actually monitor all these platforms? You don't need to give names if you don't want to, but I find myself very hard to find a reliable service that really feels like it's monitoring correctly and at least enough in these platforms, the assets of my clients. What's your experience so far? Do you have good partners monitoring all of this? It's a combination of tools, maybe.
Yeah, it's no, as you said, it's like I mean, we have very good partners, but the thing is, we really need to invest our time in order to like perfect the solution, let's say, because in order like to set the tool, in order to catch what you want to catch and to leave the other user alone, it's a process that is very, very time consuming. And it means, like sitting around the table and analyzing some actual cases, and then trying to set the tool, like the parameters of the tool, in order to be as accurate as you can.
Right.
But it's not something that we have started that late, actually. So only a couple of years ago, and so far it has proved quite successful. So no complaints.
Yeah, that's great.
It's easier for marketplaces, for communication platforms as YouTube. It's easier on those, but of course on video games, I think it's more challenging. And well, the good thing of the Olympic Games, the Olympic Esports Week, is that it's a specific event, so that takes place every time during a limited time of period. So there is like a peak of infringement. So we normally witness like a peak. So I mean, we always have some kind of IP infringements, but we witness a peak normally during the celebration of the competition. So normally we are more active on the monitoring of these specific platforms also during the competition.
And maybe what you can add is that we are lucky enough to, if we catch like infringement of the rings, we will catch maybe like 80 or 85% of the infringement, because the ring are usually, associated with other trademarks. So it's also easier to set a tool to monitor something specific versus having like a very, very broad range of different logo or whatever.
Yeah.
Yeah, certainly. Wonder if we have any more questions here. I don't see submitted in the chat. But I will say, just by looking at this last slide, how busy you all going to be for the next, perhaps, century. Figuring all of this out, building the tools, building the knowledge, building even the law around, protecting such valuable IP. And it's definitely high beam light for a lot of other IP owners, including your sponsors and non-sponsors as well. This has been very insightful. I especially appreciate and thank you for sharing the insights, and not just the glitter around things, but also the challenges and how you're facing it, how you're trying to mitigate, as Marco said. It was very, very special. To hear your experience, to hear the strategy behind all of these. Andrea, I don't know if you have any more comments.
No, just thank them. The great presentation. Thank you again.
Yes.
Thank you very much.
Encourage everyone. This is our last few minutes with our panelists. If anybody has a question, please submit. If not, I want to say thank you once again. Max, Marco, and my special thanks to Carlos as well, who couldn't be here with us today, but a great friend. Yes, I agree, Camila, it was amazing. Thank you very much for your time, for your dedication, for putting this together. And we're very happy to have you here today. Hope to have you once again in the future.
Sure, in Rio, the next time in Rio.
In Rio, here we go.
That would be great.
Thank you very much. It was wonderful.
Bye.
Thank you so much for having us.
Of
Thank
course.
you. Bye.
Bye.
Thank you. Thank you, Marco. Ciao, Max.
A propriedade intelectual é responsável hoje por até 80% do valor das empresas. Mas isso não acontece apenas porque as empresas dão valor à sua propriedade intelectual. A propriedade intelectual vale muito porque a sociedade dá valor ao esforço de solucionar seus problemas e de lhe criar oportunidades. Nosso congresso desse ano vai reunir especialistas em propriedade intelectual, juristas, economistas do desenvolvimento e da inovação para nos guiarem nessa importante discussão. O pano de fundo escolhido não poderia ser melhor: as maravilhas da cidade do Rio de Janeiro. Para comemorar seus 60 anos de existência, a ABPI reunirá os participantes nos mirantes deslumbrantes do Pão de Açúcar, ícone turístico do Rio de Janeiro, aclamado por visitantes do mundo inteiro. Durante 3 dias, teremos a oportunidade de nos encontrarmos, fazer negócios e, sobretudo, de discutir e aprofundar nosso entendimento do papel da propriedade intelectual frente aos desafios brasileiros. Da consolidação do agronegócio ao desenvolvimento do turismo e de indústrias avançadas, da transformação digital e da transição energética ao estímulo ao empreendedorismo e à inclusão social. Participe e se engaje com o compromisso social do Congresso da ABPI de 2023. Esperamos vocês de 20 a 22 de agosto na cidade maravilhosa do Rio de Janeiro.